Greetings and salutations, my fellow sovereigns. This is Vocational Science of Freedom, Saturday night civics and sovereignty class. And tonight we will be going over how to process serve corporations and municipal corporations, which is a fun thing that everybody gets to do once they finish their Vocational Science of Freedom status doc set. And tonight we will be streaming on Rumble, and you can also find us on YouTube, and all of the backup classes that we've ever done, all of the information is on Odyssey, which is the only place where there is no censorship. You can also find us on Gab at Gab Group 30721, where I post a lot of articles about teaching and the like from time to time that I don't get a chance to put anyplace else, because Gab is pretty much the only quote unquote social network that I use for VSOF. And so tonight I put the mega link into chat before, and the treatise is up. The name of it is called A Practical Treatise upon the Law of Judicial Writs and Process in Civil and Criminal Cases, and a very long subtitle. And this was written in 1895. And right around that time is when we have the heyday of common law coming along, meaning that people knew how to run their common law cases. They knew how to be in courts of record, and they knew the difference between that and being in equity. And we left off at page 258. And I do have to make a little bit of housekeeping note. In the mega file for this class, there will be two separate treatises. Now, they're the same treatise, but what I realized, unfortunately, a little bit too late, is that the one that we had been running off of and I'd been putting all the notes into and the vocabulary and all the good stuff. Well, trouble was, I got down to, I think it was like page 3 something or other, and I noticed that the whole right side of the page had been cut off. Well, damn it, I got to go find another one. And looked around, finally found one on archive.org. And so this is the second one. And what I did was I simply gave it a separate name. So in the beginning of it, this one says class 6, ... meaning the rest of this treatise will be read off of this copy, not the other one. And if I have the time, I might go back and literally switch over all the notes and put everything onto this one and then just delete the other one. But I didn't have a chance to do it before class. So just as a housekeeping note, we're running off this next one called class 6. With that out of the way, let's go ahead and we can start. The section that we're in right now is chapter 23, the manner and sufficiency of service of process on corporations. Section 105. Service on domestic corporations. The statutes of Virginia require service of process against a corporation to be on its president or other chief officer, and in his absence on any agent thereof, or on any person declared by the laws of the state to be an agent of the corporation. And made a note here, any other person declared to be the agent thereof. What this is called a registered agent. And and it'll get into this registered agent thing a little bit more in detail in the treatise, but just as for right now, every corporation that has a charter out of some state to do business has to put in to the Secretary of State the name and the address of their registered agent. That is the place that all corporations must do that, and that's where you serve that corporation. Because if the state, say, has a problem with a corporation, say it's, I don't know, dumping toxic chemicals into some lake somewhere, and says, hey, we got to sue you for that. Well, they got to have a registered agent and a place to go have process given to them. So we'll get into that in a bit as far as the specificity of what a registered agent is. But just as a short note here, I did just very simply today just click onto a web browser and I said, okay, I just put in at the top, just put in registered agent for Google. That's it. Now, if it's a really big corporation like Google, you should be able to find it very quickly and very easily. If it's some smaller corporation, say John's Fix-It Shop or something for automobiles, then you'll probably have to go to the Secretary of State's office and just simply look them up. But for most major corporations, you're going to have it pretty quickly. So it says serving civil subpoenas or other civil requests on Google, and this is how you do it, so on and so forth. And this office is right here, corporation, service company, blah, 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 so on and so forth. And this is where you would go ahead and then have a process server go and take your documents that you want to have process served to Google. And like I said, every corporation has one of these, and they all have to be in the Secretary of State's office. So that's the first place you go look if you can't simply find it online. Okay. All right, to continue. The vice president and general manager of the company were held to be agents of the corporation within the meaning of the statutes, where, in the absence of the president or chief officer of a corporation, a summons to it may be served, quote, by leaving a copy thereof at any business office of said company with the person having charge thereof. And we'll get into that in a second too. Who's actually in charge of the office. The return is sufficient that recites service by leaving a copy of the writ with AB, quote, the bookkeeper and agent of the within named defendant at and in the office of said company in my county, such and so forth, said AB being in charge of defendant's said office. In charge of defendant's said office. Okay, so if you're in the charge of the office, then you're the one that can take service if, say, it's the office of the president of, say, that corporation. So this part stated here, being in charge of said defendant's office is important. If you can't get to them, then you leave it with the one that is in the way or simply is there at the time. And another document that I added to the mega file for today's class is a sample process service affidavit. Now, any of you who have started to do your doc sets or have looked into the mega file of all the information for all the handbills for the doc set know that there is a process service affidavit in there, and that is where I took it from. So I'm just going to open this up real quick so we can take a look at an example of how you fill out a process service affidavit. And there are many different ways to do this. They don't have to be all that elaborate or crazy or whatnot. It's very simple as far as what you're doing. And this is one for what was for a habeas corpus, right? So it's set out for a habeas corpus, but you can just, everything in red you can change as to the information of what you need to put into it, okay? So I have here David Lee, House of Roberts, P.O. Box, whatever, Illinois, such and so forth. State of Illinois in the circuit, and this is where you're heading for your court is. The court that you're going to file this affidavit into. So this process service affidavit has with it a court heading. If, say, you don't have a case going or you don't even know what court you're going to file it in, just delete this whole section of the court heading. You don't need any of this if you don't know where you're going to file it yet, okay? But this being for a habeas corpus, obviously if it was known and the case number was already set up and so on and so forth. Okay, so this is how it is here. State of Illinois in the Circuit Court of the 17th Judicial District, Winnebago County. David Lee, House of Roberts, case number such and so forth, plaintiff versus Gary Kwana, defendants. That was kind of a misprint there. But anyway, you can fix that too. Defendant. All right. And then what is the thing? So as court headings go, just a little short introduction to the court headings here. The court name goes here. The plaintiff and the case number go here. You could also put the case number over here if you want, but a lot of people put it here. Plaintiff, and then you just put a V here or VS, what the defendant's name is and what the defendant is too. So if it's a corporation, you say Google Incorporated or whatnot. And then there's this silly little squiggly or dotted line. And then on this side, you have what the thing is here. So process service affidavit, and then what it's for. So in regards, in re is short for in regards. Habeas corpus for David Lee, House of Roberts. It's attested, it's signed, and it's sealed. Okay. So process service affidavit, the name of your process service agent goes here. So the agent would put their name here. So that's why it's in red. So Stephen Derek D. Bioki comes now and states that I am not a party to the writ of habeas corpus for David Lee, House of Roberts, that I am over 18 years of age, that I am one of the people of Illinois, and that establishes the process service agent's sovereignty from the standpoint of being one of the people, and that I have served 1 file stamped, certified, endorsed copy of a writ of habeas corpus in re David Lee House of Roberts, 1 copy of petition for writ of habeas corpus by a people in state constructive custody, not sentenced to death, notice of default, and 1 copy of attachment A of said petition, law of the case. 2, Sergeant T. Roberts on September 2nd, 2018, who, and this is the thing about being in charge of the office, who at the time of service of the aforementioned documents was a deputy sheriff of Winnebago County, Illinois, an employee of Winnebago County, and apparently in charge of the office of the Winnebago County Sheriff, because the process server could not get to the sheriff. The sheriff was either in the back or he was someplace else, but it didn't make a load of beans. It was not necessary to actually get it to him. He came to the office. Deputy said, "What do you want?" He said, "I have service for the sheriff." And as I recall, I believe he said to me that the deputy said, "Well, you can't see him," or some, little snippy little line like that or something. And he said, "Okay, fine." And he said, "What's your name?" And the guy said, "Well, my name is Sergeant T. Roberts." "Okay." Throws it on the desk, walks out. Right? That's it. The guy had been served. All right. So Sergeant T. Roberts was there. My process server couldn't get to the sheriff because of said sergeant. He drops it. He says, "The sheriff has been served." He walks out. That's it. That's all I got to do. Nothing crazy, nothing fancy. He's done. Because Sergeant T. Roberts here was apparently in charge of the office of the Winnebago County Sheriff, right? Okay, now I'm going to read the rest of this, and then we'll get back into the treatise for a second as to why this is important. Okay, all the aforementioned served documents are on file with the clerk of the court, case number such and such. So you put your date. When did you serve them? When was the time that you served them? What was the sex of the person you served? And technically, that should be a man, not a woman, considering it was Sergeant so-and-so. The service address. So where was the exact place that you served so-and-so? Plaintiff or claimant, David Lee House of Roberts. Defendants, such and such. And again, the defendant's a little bit messed up here. I should just say defendant. I don't know why that was a little bit messed up, and then you put your defendant, okay? And that's it. And then the test day is that you go and you get it notarized, which is pretty much a requisite in any state statutes regarding due process of process service affidavits. You pretty much always have to go and get it notarized. If you had a couple witnesses with you, like 4 people, and you served it, like say you were the process service agent, let's just call it process server. Sorry. So you're the process server. Say you took 3 of your buddies with you. Well, you could put 3 of your buddies down and they could testify that they saw you do that. 3 witnesses is just as good as a notary public. And forgive me, I don't remember exactly where I learned that. I believe it was out of a treatise dealing with notary publics. So anyway, you can take 3 of your buddies or just go get it public notarized. It says, "I am Stephen Derek D. Baiocchi, one of the people of Illinois. I have personal knowledge of the above stated facts and am competent to testify as to the truth of these facts if called as a witness. I am the above stated process server. I declare under penalty of perjury under the laws," and this part's important, "under the laws of the United States of America, that the foregoing statements are true and correct, period." And then served by, that's where he signs it, signed and declared before me, such and such, that's where notary public signs it. And there's a space here left. If your process server has their own seal, they can put it here, and then the notary public usually puts their little stamp here. And that's it. Okay, so why is this important? I declare independence of perjury under the laws of the United States of America. Okay, if you put, "I just declare under penalty of perjury," at least when you're dealing with federal matters, it states that if you do that, then it's considered quote unquote with the United States, meaning with the federal corporation. But it specifically says in the United States Code in USC that if you put "under the laws of the United States of America," that you are without the United States, meaning without the corporation. So that's why I always put that in there. And somebody said to me, well, I don't want to be, you don't want to be under the laws of anything or that and whatever. I said, no, you don't understand. Go read U.S. code, right? And I told them to go find the section and whatnot. So that's why that's important. And then that's it. That's the end of the process service affidavit. And at the bottom, it says amended process service affidavit. So you guys can check that or just fix that and just get rid of the amended part, because I had to fix this at one time. So I'll just save it like that. And then you would file, well, first off, they fill this out, your process server fills this out, then you take it and you file it into the court case of which the matter is, pending, whatnot. And that's it. That's how you do process service. If you just have your special master or one of your marshals of your court of record do that, the way that I had that one written was where a special master had gone and served the sheriff. And I believe they even asked him, it might not have been the sheriff's office that asked him, it might have been somebody else that asked him. They said, well, who are you? And he said, well, I'm a special master for the Superior Court of Winnebago. And that shut them up right away, because they were like, they didn't even quite know what it was. And also, just for those of you who have listened to the class 5 of this, and I told the story about my special master serving the clerk of the court. Well, this is the same guy. Okay. And so he was walking around, saying, yes, I am a special master. And I told him to take the paperwork with him. So I was like, all right, take the paperwork with you and make sure that if anybody asks you who you are, just say, I'm a special master. And they go, well, you can't be that. And then just drop a copy of the special master appointment to the superior court in their face and just, go about your business. So anyway, that's how you do that. And your special master or your marshal can do it, or anybody who's over the age of 18. So back to the treatise where it says, and then leaving a copy of, to said AB being in charge of defendant's said office. So again, they won't let you pass. Okay, apparently Sergeant whoever was in charge of the office for the day. Put his name down, get done with your business, get out of there. By statute of service of summons was authorized to be made on non-resident defendants out of state, and such service was given the same effect as service by publication. Now, we talked about service by publication, I think 1 or 2 classes back, so I'm not going to rehash that again. But this provision was held not to authorize service of summons in the state on the president of a foreign corporation having an office in the state. The Kansas statute require railway corporations to designate persons on whom service of process may be made. Where a company has failed to do this, service on a, quote, local superintendent of repairs was declared void. Now, what it had failed to do this, do what? Make sure that there was somebody that was a special, actual registered agent, okay? Where service of summons is authorized to be on the president or other chief officer, cashier, or any director of a company, service on one director and the cashier is valid. Though they allege in their answers that they have no power to plead officially, which is fine, doesn't matter. If it says what it says in the statute, that's who you can serve as far as the due process rules of civil procedure for, say, California, whatever, then that's fine. Serve it on them, get out of there. Because it's kind of a pain in the ass to have to literally serve the president of a corporation. But again, however, this is the reason why this has been taken care of with the uniformity of every corporation having to make sure that they put in who the hell their registered agent is, and it sits with the Secretary of State for any corporation that's chartered out of said state. So you don't have to go through this crazy rigmarole of, well, what does the statute say? Does it say I have to serve the president? Does it say I can serve the vice president? And where are they at? Is their office over here? Nope, it's all taken care of. You don't even have to worry about it. Just get to the registered agent, find it, be done with it, okay? Okay, and then the recording agent of an insurance company whose business is merely to write policies and see to the interest of the company concerning property insured by him is not an agent employed in the general management of the company's business within the meaning of the statute. Service of summons on the assistant treasurer of a corporation is not valid under an act requiring service to be on the president, secretary, cashier, treasurer, director, or managing agent, though the treasurer is a non-resident. Neither can such service be sustained on the proposition that an assistant treasurer is a quote-unquote managing agent, he having nothing to do with the management of the business of the company, his duties being to draw checks payable to the order of another clerk of the corporation. And we're going to skip down to the next part here. And under the statute is held, and this was a different, talking about a Michigan statute here, but I just want to read this little part. It's interesting. Under the statute is held that it is not necessary to serve the process in the county in which is located the principal office of the corporation, but that service on the president in the county in which the plaintiff resides is sufficient. Again, this is taken care of with the registered agent issue. Again, that's why that says, to be sure that you have properly served the corporation, be sure to find the address of the registered agent in the state where you are domiciled and have them process served. And service of process on one who had been president of the defendant corporation, but who had resigned from the office prior to service, cannot be maintained. So if somebody leaves, and we'll get into this a little bit more when it deals with municipal corporations, there's kind of a funny story in here regarding a mayor. But just because if you go ahead and you leave, or if you've completely resigned prior to service, then the service upon you for the corporation cannot be maintained. Though the president of a corporation be actually present in the county, yet if he cannot be found, service of summons may be made on other officers of the company under the statute, which provides that if the president cannot be found in the county, the service may be made on certain other officers. All right, skipping down a bit, down to page 263. An officer was proceeding to serve process directed against a corporation on its president, as he was informed, when the person and the treasurer of the company stated that the officer was mistaken, that another person was the president. The officer then made service on the latter, meaning the process server. Afterwards, the corporation attempted to avoid the service by showing that the person served was not the president, but this was not permitted. So that's where you get this goofiness where, the corporation's trying to play games and trying to say, oh, well, you can't serve us over here. We don't know who you are. Or we're going to try and pretend like we don't know where the president is. Or, well, this guy was actually the president. Or, well, wait, no, that guy was, and try and mess around with you. Well, that's clearly not allowed. They cannot do that. So whenever they start messing around like that, there's no way that they can bounce around and say, oh, there's no officer here, or he left yesterday, or he decided to resign yesterday and we don't have a new president, or whatever the goofiness of the situation is that they're trying to get out of literally being served. That simply does not fly. Okay. So there's nothing they can do to get out of it just simply by saying, oh, we don't know where he went, or, oh, we don't have a president at the moment. Sorry, that's not going to work. All right, skipping down a bit. To render a writ of mandamus effective, it must be served on the officers of the corporation who have the power and duty to execute it. Right? So, and a writ of mandamus is a high prerogative writ, and it basically means, by mandate. So, let's take the example, say a state attorney general does a writ of mandamus against a corporation to, say, stop putting chemicals into a lake, right? They do this, so on and so forth. Well, if they serve the writ of mandamus on some rent-a-cop that works for the corporation, or if they served it on some delivery driver that's out and about, well, they don't have the power to execute it. They don't have the power to go to wherever the place is that the chemicals are being dumped and say, you got to stop that because I've got a writ here, right? No, you have to serve it on whoever has the power to execute it, and against whom an attachment to and enforce obedience to it may issue. So again, the capacity to actually do what the thing says to do. Skip down a little bit. The return of service of process is insufficient, which recites merely that a copy of the summons was left at the business office of the company. So you guys can't do that. You can't just drop it somewhere and hope that somebody picks it up. No, that's why you got to get the name. Okay, with the person in charge thereof, the chief officer being absent. Absence under the statute means absence from or could not be found in the county. Mere absence from the office will not warrant service on a person in charge of the office. So that's why you have process servers, and sheriffs will do this too. If they have to, or a federal marshal, whoever, if you have to serve a man specifically, well, that's different than if you go to their office and they're not there. Okay, you need to go back until you can find them there, if you can't find them at their house or any other place where they, should be located, right? And that's what this is talking about. To continue, the marshal's return that he served the writ on one reputed to be one of the directors, and the record showed that the person served was a director at a previous time, cannot be objected to on trial as being insufficient, especially as the corporation had appeared by attorney. So that gets into what we spoke about a few classes ago, when you can waive your rights regarding, well, I should put it this way. You can waive your right to argument of that there was some violation of due process by simply appearance. So that's kind of what this is getting at as well. If you make a general appearance or you appear by attorney, anything that might have been a due process like problem or irregularity or just outright mess up, you waive by doing a general appearance. So just know that, like I said before, if something comes up, object to every single thing that they do wrong, and make sure that you actually file something that says, yes, you did this, and yes, I'm wanting to file a motion to either strike whatever or dismiss whatever, or literally get rid of the whole suit for whatever. Do not let your opportunities to have remedy based upon what they've messed up ever go by because you lose them. So, all right, skipping down to page 270. Under the common law jurisdiction, could not be acquired over a foreign corporation by the service of process on one of its officers. But under statute, a foreign corporation may be subjected to the jurisdiction of the courts of a state by personal service on the proper officer, and such service is equivalent to personal service on a non-resident natural person. We'll get into a natural person in a minute. No attachment of property is necessary. Corporations are artificial persons, existing only in contemplation of law. They're just a spell. They're just a mystical little thing. They don't really exist, only in contemplation of law. They must dwell in the place of their creation and cannot migrate to another state. But they may be sued, like natural persons, in transitory actions arising ex contractu or ex delicito, in any state wherein legal service of process may be had. So, okay, so I am going to make a little point here. Now, so what's the difference between a natural person and a fiction of law? So I've got two things. One, I've got the definitions here, which I'll go over. And two, I have a bunch of other definitions that I want to go over regarding this point, because this is a very misunderstood point in law, particularly with a lot of people out there, a lot of these gurus out here who think they know what they're talking about. I could name names, but I won't. So let's just go over this whole thing about what is a fiction of law, what's a person, what's a natural person, and just put this fucking shit to rest once and for all, right here, right now. Because I'm really tired of having to answer these questions. And I've been doing it for 20 years because everybody keeps saying the wrong thing. They keep teaching nonsense out here. Okay, so to continue with my rant. Now, some people have argued to me that we are, quote unquote, natural persons and should state that within our paperwork. This is incorrect. You take a look at the definition sheet for this class, which I'll pull up in a second. When you look up the definition in different locations and states, it says that a natural person has the capacity for rights and duties. Okay. The dog has the capacity to go fetch the stick. Does that mean that the dog will go fetch the stick? No. You, being born before you've come of full age, are an infant. You have capacity for rights and duties. You have capacity to hold title. But until you have come of full age, you cannot do either. Okay? So a natural person is not something you ever want to call yourself. Furthermore, as we know from 1 USC subsection 8, under the definition section, person, human being, child, and individual, as including born alive infant. A, in determining the meaning of any act of Congress or of any ruling, regulation, or interpretation of the various administrative bureaus and agencies of the United States, the words person, human being, child, and individual shall include what? Every infant member of the species Homo sapien who is born alive at any stage of development. So can you be 45 years old and be an infant? Yup. Is that what they're calling you in the United States Code? Yup. Is a natural person an infant? Yes. Now let's take a look at that. I'm going to open up the definition sheet here, and let's take a look at legal fiction first. Well, we did legal fiction before. All right, let's get down here. So natural children, because guess what? It doesn't actually define natural person in Bouvier's. Why not? Because natural person is not a term at law. It's a Roman civil law term, right? Of course. And I'll show you where this connects here. Okay, natural children. In the phraseology of the English or American law, meaning common law, natural children are children born out of wedlock or bastards, and are distinguished from legitimate children. Okay. But in the language of the civil law, and whenever you see civil law, it always means Roman civil law, natural are distinguished from adoptive children. That is, they are the children of the parents spoken of by natural procreation. Great. So what's natural children? Natural person. So natural person, natural children, they're bastards. Makes perfect sense. Goes right along with everything else we already know. Right along with the fact that the birth certificate has a different name for your mother and your father. Has your mother's maiden name and your father's proper name, his proper surname. But what does that look like on the document? It makes it look like, guess what? They're not married and you're a bastard. Why do they have to do this? This is the reason. And everybody needs to wake the fuck up that this is exactly what they're doing. Their verbiage never changes. They're always doing the same thing. They're always calling it the same thing. You just don't know where to go bother to look for it. Okay? So, that's a natural person, natural child, a bastard, an infant, one who has the capacity for rights and duties, but doesn't necessarily exercise them. Because if you are exercising all of your rights and duties, you would have come of full age, as is stated in the Magna Carta. Go read Articles 3, 4, and 5, as I've said ad nauseum. Then you'll see that you have all of your rights and duties, and you can then hold title. Infants can't hold title to anything. Not to land, not to cars, not to guns, not to anything. Why do you think all the infants have to register their title? Because daddy is going to take care of you. Daddy's going to tell you what you could do with your car. Daddy's going to tell you what you can do with your own body. And daddy's going to tell you that you have to pay rent for the rest of your life in something called property taxes. Well, fuck you, daddy. It's my title. So what do you have to do? You have to claim it. You have to get rid of all these fucking presumptions and claim your estate back. If you don't do that, you will stay a child. You will stay a bastard. You will stay an infant under Roman civil law. And they will administer your ass to the grave. Okay? Good. Next one. Corporation. This is from Black's Ninth. An entity, usually a business, having authority under law to act as a single person. A single person, huh? Distinct from the shareholders who own it and having rights to issue stock and exist indefinitely. I could get into the whole indefinitely part and the statute of mortmain, but I won't. Let's just leave it at the point that corporations should never, ever, ever be able to exist indefinitely. So there was a serious statute about that was put down in England called the statute of mortmain, that you could not give things to things that never die. Now, they were specifically focusing on the church back then, but of course the church is a corporation sole, at least when you're talking about the Catholic Church, good old Pope. And it's also a fiction. But to continue, a group or succession of persons established in accordance with legal rules into a legal or juristic person that has a legal personality distinct from natural persons. Okay. They're both fictions, the corporation, right, the juristic person, and distinct from natural persons, who has the capacity, maybe, someday, to grow up. But who exist indefinitely apart from them and has the legal powers that its charter gives it. Also termed corporation aggregate, aggregate corporation, body corporate, corporate body. Quote, a corporation is an artificial being, invisible, intangible, and existing only in contemplation of law. It possesses only those properties which the charter of its creation confers upon it. That's Trustees of Dartmouth College versus Woodward. So on and so forth. And then Black's Ninth, another one. Ens legis, Latin law, a creature of the law. So ens legis is any corporation sole, any trust, anything that's got charterability to it. Is a creature of the law, an artificial being, as opposed to a, again, natural person. The term describes an entity such as a corporation that derives its existence entirely from the law. So you can kind of see in these two definitions, if you were to just only open up Black's Ninth's dictionary and start looking to see, oh, well, what should I be calling myself? Well, I'm not a corporation, right? I'm not a legal entity. I must be a natural person. Wrong. You are one of the people of the several states of the American Union. You have come of full age. And you are a sovereign. Do not look to Roman civil law to help you in anything that you try to do in this world. There is no remedy there. There never will be. And anybody that keeps telling you to go look for it in Roman civil law is an idiot. You look for your remedy in the foundational documents. You look for your remedy in understanding your own power. What can a sovereign do? Oh, they can convene a grand jury. What's a grand jury? It's called the fourth branch of government. What? What's the fourth branch of government do? It destroys all the other three below it whenever they fuck up. That's what a sovereign can do. Is anybody doing it? No. Because we've all been taught that we're natural children. We're just playing in a sandbox with Monopoly money. Anyway, I digress. Back to the treatise. Next part. Many of the states, by constitutional or statutory provisions, now requiring foreign corporations to maintain a place of business in the place where they do business and have an agent therein on whom process may be served, as I just formally stated. The corporation is required to file a certificate with the Secretary of State containing the name of the agent and the place of business of the company. So go find them there, known as a registered agent. By such requirement, the service of process on foreign corporations is simplified and rendered certain. Compliance with these provisions has been stubbornly resisted, and of course by corporations, and the law attacked as being in conflict with the provisions of the federal constitution, which guarantee to the citizens of each state all the privileges and immunities of citizens of all the several states. How the fuck did a corporation ever get privileges or immunities as if they were a de jure state citizen? I could get into the case, but it won't. Basically, it was a bunch of attorneys that weaseled it past the Supreme Court. And the corporation said, oh, we're a person. We're a person. But anyway, and they tried to take it to this extent. And pretty much everybody, including the Supreme Court, said, no, nope, not going to do it. All such resistance has met defeat, and the constitutionality of such requirements is firmly established. So, skip down a bit. A writ of mandamus against a foreign corporation engaged in business in New Jersey, commanding the performance of a duty growing out of that business, may be served on any officer of the company in that state, on whom service of the writ would be proper under what? The common law, if the corporation were domestic. There's this weird thing about common law and foreign corporations. And the reason is that a foreign corporation should not be able to do anything or have any effect whatsoever regarding a common law jurisdiction in the sovereignty of which they might be found. But we get around this from the standpoint of the registered agent and this interesting intermixing, as it was stated above, about quote unquote the privileges and immunities of all the rest of the several states, blah, blah, blah. Well, corporation doing business in one state, say in Texas, if they decide to start doing business in Illinois, they're not considered foreign, technically, because, okay, you're registered there, you're of the several states. And so you have this weird crossover that, yes, the corporation is from Texas, but they're in Illinois now doing business as well. Okay, they have the same things that they have to do over there, meaning if they violated a law in Illinois, well, they're subject to the Illinois law. Just because they're chartered out of Texas is irrelevant. So just kind of think about that it's a little bit different here in America because we have this thing about sharing the rights and immunities and particularly the laws of each one of the actual states of the Union, which are the separate actual countries because they have governors, not presidents. But anyway, skipping down. It is said that a foreign corporation has a legal residence in a state where it maintains an office and keeps an agent. But the more reasonable view is that corporations are citizens and residents of the state under the laws of which they are created, and that they cannot acquire residence in another state by engaging in business there. Service on a foreign corporation, which has not designated a person on whom process against it may be served on its managing agent, again, that registered agent. If a corporation organized under the laws of Colorado has an office in New York City and nowhere else, and all persons competent to represent it live in New York, service may be made on its officers there. A foreign corporation cannot escape service by refusing to appoint an agent on whom process may be served as required by the law of a state. So again, this is this whole thing about even if the corporation doesn't go and file the registered agent, which they're required to by law if they want to actually do business in said state, and technically the attorney general could file a writ of mandamus or quo warranto against that corporation if they don't put up a registered agent for service. All that being aside, they still cannot simply refuse just because they haven't put up the registered agent as required by the state law. Okay. So you can't just jerk process just because you want to hide. Skipping down quite a bit here because I skipped like a lot of the rest of this. Because again, this is a lot of stuff about, and we get into a different section here as well. So a lot of this other stuff was just back and forth about if an agent was here, if an agent was there, if he was at his house, if you found him out eating lunch, that kind of stuff, which is stuff I don't want to get into. All right, section 107. Service on officer of foreign corporation while in the state on private business only. Okay, so this is kind of one of these little weird things. It is said by Mr. Justice Field that an officer of a corporation does not carry his functions with him when he leaves his state. So if you found the president of Google and Google's in California, registered agent's supposed to be there, and say the president's having a fishing trip in Florida, technically, can you serve him there? The answer is no. Okay. But to read the top part here, it is not now to be disputed that a judgment in personam against a foreign corporation rendered by virtue of service of process on a representative of the company while in the state transacting business for the company, being authorized by statute, is valid and entitled to credit and susceptible of enforcement in another state. But whether such a judgment based on the service of process on an officer of a foreign corporation who is temporarily present in a state on purely private business, like going and catching that fish, and not in his representative capacity, is a question that has furnished cause for much judicial decision and which is of paramount importance. The federal decisions concerning the subject will be first presented. So I don't want to get into this a tremendous amount, but there are a few little snippets in here that are kind of fun. Next one down. We are of opinion that when service is made when in the state upon an agent of a foreign corporation, it is essential in order to support the jurisdiction of the court to render a personal judgment that it should appear somewhere in the record, either in the application for the writ or accompanying its service, or in the pleadings or the finding of the court, that the corporation was engaged in business in the state. So again, finding Mr. President of Google in Florida having a fishing trip doesn't fly. Skipping down to section 108. Same subject, author's view. The reasoning in the case upon the subject is neither satisfactory nor persuasive, notwithstanding the great weight of the authorities is against the validity of such service of process on a foreign corporation. A recognized writer upon corporation law asserts that, quote, there is not the slightest reason why service of process upon a foreign corporation at common law should not be governed by the same principles and rules as service of process upon domestic corporations at common law. Like I said, there was this weird thing about foreign corporations regarding common law. I don't know where it came from. Probably some strange oddity in English jurisprudence that I don't want to get into, nor do I wish to go try and find. But I agree with what was just stated. Because they're on our soil doing the thing here, so whatever, your subject. But to continue, it is to be concluded that a corporation, the artificial body, has its residence only in the state where and under the laws of which it was created. This is more than a figure of speech. Quote, a corporation can have no legal existence out of the boundaries of the sovereignty by which it is created. It exists only in contemplation of law and by force of the law. And where that law ceases to operate and is no longer obligatory, the corporation can have no existence. It must dwell in the place of its creation and cannot migrate to another sovereignty. Close quote. You're in your box? Stay in your fucking box. This principle is the foundation of the rule of the common law that the service of process on a corporation must be made through its head officer in a state where it was incorporated. That's the common law rule. And everybody, just to make a note of that, that's really what the common law says, okay? So that's why you're doing that. The growth of the country and the necessity for corporations to transact business in any or all of the states has brought into existence that courtesy and politeness denominated commonly between the states, by which one state permits a corporation of another state, not being forbidden to do so by the laws of its sovereignty, to engage in business in the former. This privilege logically produces a correlative obligation of a corporation to submit to the laws and jurisdiction of every state where it does business. This matter was thus anamneaverted. I've never heard of that term before. To in early cases, if, quote, if upon principles of law or comity, corporations created in one jurisdiction are allowed to hold property and maintain suits in another, it would be strange indeed if they should not also be liable to be sued in the same jurisdiction. For if we recognize their existence for the one purpose, we must also for another. If we admit and vindicate their rights, even-handed justice requires that we also enforce their liabilities and not send our citizens to a foreign jurisdiction in quest of redress for injuries committed here. Close quote. These remarks are unanswerable and announce the recognized variation of the rule that a corporation, quote, must dwell in the place of its creation and cannot migrate to another sovereignty, close quote. It may migrate to another state for its purpose of engaging in business there, and when it does this, it dwells there for the purpose of being sued and served with process. Okay, Skippy Downy, Section 109, Service on Municipal Corporations. This is kind of the fun part, because this is when you start talking about serving police departments, mayors, and the all too fun and ongoing present service of school boards recently for all kinds of manner of filth, which I won't get into at the moment. So here we go. It is required by statute in Wisconsin that service of process on a city shall be made, quote, by leaving a copy of the process with the mayor. So you want to serve and sue a city? Find the mayor's office. Walk in. Are you the mayor? Yes. Leaving a copy of process with the mayor. There you go, buddy. You're served. Now, of course, don't do this for your own court case. If anybody hasn't gone back and this happens to be the first one of these classes you're listening to, do not serve your own process. Okay. If you're the one, you're the plaintiff, you're bringing the suit, do not go serve your own suit. You have to have a disinterested third party. Okay. Who has come of full age and has no interest whatsoever in your suit. Only then can it be considered to be proper lawful process. But to continue, under this provision, it is held that, but you can certainly go with your process server and as a witness if you like. That's always fun. It's always fun to watch the faces of people when they get served. But anyway, under this provision, it is held that the mayor is the only officer on whom process against the city may be served. Where the office of mayor was vacant and there was no president or presiding officer of the common council, service on chairman of the board of street commissioners and on the city clerk was held to be insufficient to support a judgment by default. Now, I would never do a judgment by default one way or the other as far as that's concerned and going against the city. I would always probably want to go through having the fun of running them through court anyway, but that's a side note. To continue, and where under this statute and the further one providing that the registration of the mayor, that the resignation of the mayor should be in writing and filed with the city clerk and should take effect at the time when filed, it was held that service on a city could not be made by leaving a copy of the writ with the mayor after he had filed his resignation. But this one, however, the laws of Texas provide that, quote, all office, and this makes a lot more sense too. I think every state should be like this, right? Hopefully they have come around to being like this. Okay, the laws of Texas provide that, quote, all officers within this state shall continue to perform the duties of their offices until their successors are qualified, close quote. Now, I wish all corporations would do that, but at least all of the officers within the state. So that's all the state officials. That doesn't necessarily mean Dallas, Texas. So if you went to go sue Dallas, Texas, you're still dealing with the mayor. But this is different. This is dealing with all officers within the state of Texas. So basically, there's never a time that the office is vacant. That's the whole point, is that you can always process serve somebody for the problem. All right, skipping down. Under a statute requiring the service of summons against a corporation to be on, quote, the president or other head of the corporation, close quote, service on the president of the board of trustees, which, quote unquote, governs the city, the president of which board is declared to be the, quote, general executive officer of the city government, head of the police, and general executive head of the city is valid. If the act requiring a quasi-public corporation does not provide for organization with any head officer, service on all of the members will be valid in the absence of proof of organization. We're getting into a lot of quasi-public corporations in America. I didn't specifically set aside any explanation of this, but it's kind of like everything now. And I know that's a horrible way to try and explain this, but okay, all right, what am I getting at? Things like the aspect that all of the district attorneys of all counties, they all have their own Dun and Bradstreet number. And if you go and look them up on Dun & Bradstreet, what most of them say is that they'll say John Doe also traded as Boone County. Well, what? Okay, that's a quasi-public corporation. And it's a corporation that's pretending it's government, but it's not. And that's a problem because we have nothing but corporate governance anymore. That's all it is. We're all being run by corporate government. No one's standing up and saying, hey, wait a second, you don't have any jurisdiction over me. And certainly no one is stopping to look around and saying, hey, maybe I shouldn't enter into that contract with this thing over here, saying that it's the state of Illinois, but it's really Walmart. And obviously it's not Walmart, but you get the point. It's Walmart pulling you over on the side of the road. Again, but you get the point, right? Why would you have any reason to pull over if somebody in a Walmart truck put a blue light and got in a fucking clown suit and said, pull over? Why would you do that? You wouldn't. Unless they're pointing a gun at you, which usually they do. But if you have a contract with the clowns at Walmart that say that you can't drive their Walmart car any faster than 55 miles an hour, and you have a tattoo on the car called a license plate that says to the Walmart clowns that the car is registered and belongs to them, well, then you got a fucking problem, don't you? Because you're in contract with Walmart. I hope everybody understands that analogy, and I hope you get it through your head. Because this is all about contract and consent with corporations. It hasn't a goddamn thing to do with the law. But anyway, I digress. Last part here. It may be remarked that where by statute the service of process against a municipal corporation is to be made on a certain officer, service on any other officer will be invalid. The statutory provisions must be followed as to the manner of service and the officer on whom service is directed to be made. If no particular officer is designated by statute on whom process must be served, the service must be made on the chief officer of what? The municipality. That goes for counties. That goes for cities. I think it would also go technically for townships, but I don't know if technically townships are considered municipalities. I think they are. But so that is the end of reading for this evening. Now I'm going to unmute chat. Does anybody have any questions, comments, or interesting stories about process service? And again, whilst you guys are finding your unmute buttons, we hold class on Mega. It is a encrypted cloud share platform, which the United States Federal Corporation cannot access because they cannot get to the codes of it, which is why we share all of our documents and all of our links for all of the classes on Mega files, and which is where we also have class. If you'd like to join the class on Mega, you must first join the Vocational Science of Freedom on Revolt. And in order to be on Revolt, you have to first come and get the welcome package. And you can download the welcome package, the link of which is in all of the show notes in all of the classes for every single class that we've ever done. So if you want to join, do the welcome package, get vetted, join Revolt, come on in here, join in the learning. And then if you play nice and you follow the rules, then you can ask to join and be in the live classes on Mega. And so that's what we do with the welcome package. We show you how to set up all of your secure comms, okay? Meaning communications between us here on Revolt and also on Mega as well. So anybody else, last call for questions, comments, or anything else? Let me just go back through chat here and see if I didn't miss anything. Okay, doesn't look like there's anything else in chat for the evening. So with that, make sure that everybody goes back and listens to all of the rest of the due process classes. Again, this is class number 6 that we're on for tonight, and the rest of them are in playlists on Odyssey. And another thing as far as just kind of playlists are concerned and how to find a lot of the VSOF information, the best place to go is onto Odyssey if you want to find everything that we have. And then if you want to look for something specific, say you want to talk about due process or whatnot, you click on content here. So there's home, content, and playlist. Now there are a lot of things in the playlist, that's fine. But if you want to find something specific that we might have talked about in the past, click on content, and then come here to this little search button and hit search. So if you want to say, I don't know, look for when we talked about arbitration, it'll pull up all of the classes that we've talked about arbitration. Okay? Because I put it into the show notes what we talk about, and so therefore it can find it. So if you want a full library of what the VSOF has to offer, just make sure that you guys join Odyssey, and the link to do so is in the welcome package. And then make sure that you follow us on Odyssey as well, so that you know when new things get posted up. Okay, so with that, I'm going to call it a night. Thank you, everybody, for coming and participating, listening, and forgive me for a little bit of my ranting this evening, but sometimes it's necessary. So have a wonderful rest of your weekend, and until next Saturday, stay safe and stay sovereign.
Oh, say, can you see?